Hi, I wanted to welcome you to the Divorce Planning Podcast. I'm Carri Goldring, and I'm in the mortgage business, and I do planning pre-divorce for people who are either going to refinance their home, do an equity buyout, or plan to purchase a new home and make sure that everything in the divorce decree is worded properly and the numbers in the planning is taken care of so that you can go through the underwriting process smoothly. And I would like to introduce you to other people who are interested in the divorce planning process so you can get a real education of what's involved. Hope you enjoy. Hi, today I have with me attorney Symantha Heath, and we are going to talk about the different types of mediation. And I am very excited to have you, and I'd love you to introduce yourself and then we'll get started.
Well, thanks for having me. I'm a divorce attorney that practices primarily in the Tri-County area outside of Detroit. And practicing 30 years, I've probably at this point done thousands of mediation. And I'm also a certified mediator myself. So happy to answer any questions that you have.
Wonderful. So can you start by explaining the different types of mediation and maybe when you would use one as opposed to another?
Sure. There's two main types in Michigan. The first one is facilitative. The second one is evaluative. We primarily use facilitative mediation in Michigan, and that's when both parties will meet with a neutral mediator. That person is usually also a divorce attorney that's experienced in the area. And that mediator will work with the parties to try to reach a mutually agreed upon resolution. Now, that can happen in a couple different ways. Sometimes the parties are going to be in different rooms, and the mediator will go back and forth between the parties, and that can either be physically at an office or it can be through virtual Zoom rooms. And that's probably the most common one we do. And in going between the parties, the mediator's job is to slowly reach resolution on all the issues. And the mediator in that type of mediation cannot offer legal advice, can't offer, or typically does not offer any kind of opinion as to what the best resolution of the case would be, but really works towards getting the parties to come to that realization. With information. So the mediator in that situation will give an idea of what the parameters of the law are, and they can make some suggestions about what parties in other cases may have found effective. That's what we see most often, where the parties are not in the same room. The other part, the other option when we're doing a facilitative mediation is where the parties are in the same room altogether. For small issues or issues where we really need to come to a quick understanding of everybody's positions and exchange facts relatively quickly, sometimes that type of mediation method is very effective because we're hearing from each of the parties in real time. I will do that type of mediation in some circumstances, but I would say that happens more rarely, that we're all in the same room. And the reason is because most people are pretty emotional when they're going through the divorce process. And sometimes having to face the other person in that type of environment is very intimidating. It's very emotional. And it doesn't always lead to the best results. A lot of times it ends up kind of putting people in a little bit of a mood not to negotiate when they have to see their spouse directly. So in certain circumstances, we'll recommend that, but most of the time we're going to do what's called or referred to as a shuttle mediation method, which is where the mediator goes in between the rooms, either a virtual room or a physical room, and slowly builds up to a mutual agreement. The other type of mediation that we sometimes see is called evaluative mediation. And in that process, we start out like we would in the typical mediation, the facilitative mediation, where the mediator will meet with both parties. However, the parties agree prior to starting mediation that they would like to have the mediator evaluate their respective positions. And at the end of the mediation, provide an opinion as to how the mediator thinks the case should settle. And along with that opinion, the mediator may also provide the parties with some additional information about how they assess the case would do in court, what a judge is likely to find in that circumstance. That's not required that you have the mediator request the mediator to do that, but it's always an option. And sometimes we will actually start out thinking that we're going to do a facilitative mediation without an opinion from the mediator at the end. And the parties will find that at the end of the mediation that they think they could both benefit in further settlement discussions if they had some idea of what the mediator's opinion is after hearing about all the issues.
So would you say a mediation is usually for a specific event, like maybe discussing support or visitation, or is the mediator typically like going through what I would think of as the whole judgment of divorce and going back and forth for everything?
Most of the time, your mediation is part of a divorce action. And so most of the mediations I see are the mediator is resolving all of the issues that the parties are currently facing and need resolution on. So that will probably be division of property, division of debts, assignment of assets, whether there's going to be spousal support, if it's a spousal support case. And often, if there's children, you're going to be discussing a parenting plan as well. So it really is designed to encompass all of those issues. And the goal is that when we leave mediation, if it's successful, that the parties have resolved and agreed to all outstanding issues.
So could some be resolved ahead of time or typically no?
You can resolve some ahead of time, and that's great. I often hear clients say, is there a way to make our case less time consuming? Can we have discussions before mediation if there's areas we can work out before? Is that okay? That's absolutely okay. If you and your spouse are able to reach some agreements on, let's say, how to divide debt, but you still haven't agreed on a parenting plan, I always encourage people to do that. It'll save everybody time and money, and it's one less issue that we have to talk about at mediation.
Okay, and mediation isn't always court appointed, correct?
Yes and no. So if your case is not resolved by a certain timeline within the case, your judge will, in most circumstances, order the parties into mediation. The one exception for that is if there is domestic violence, to the extent that we feel that we cannot protect one of the litigants. In that case, the judge will not order mediation in those circumstances. But in all other circumstances, if you're not settled, if your case is not settled at about the 6-month mark, we will see an order from the court requiring mediation by the parties. However, we sometimes see people agree to attend mediation before the court orders it. So in that situation, it is voluntary to start that process early. And I do have some clients that sometimes like to expedite their case. They don't want to wait till the judge orders it. They feel like they're ready to start discussions earlier than the court would normally order it. So we will put them into what's called early mediation because they are both ready to start those discussions.
And would you say there's any like tricks that the mediator would use to get people to agree to things that maybe wouldn't happen when it's just the two attorneys talking, or is the environment different, or why does it work better, I guess, might be a better
I
question.
think that's a great point there. The environment is often different from what the parties have been experiencing up to this point. So often people don't have the words, or they can't set aside the emotions to have productive discussions about division of assets or parenting plans. And often their attorneys are giving them great advice, but perhaps not providing an alternative perspective as effective as a neutral can. So having that neutral mediator in place often facilitates agreements much more easily than it does if we just have two attorneys that are advocates, but not necessarily effective at explaining the other side, or potentially that maybe they're not effective about explaining what could happen if we don't reach resolution, what a judge is likely to do. Sometimes that discussion just isn't happening prior to mediation.
Right. And I could see where some clients would say, well, you're my attorney, you need to advocate for me, you need to fight for me. And then it's a constant fight, argue, where maybe if you have that mediator that comes in and you're like, I know we want to push this issue, but we're trying to resolve, and the mediator suggests this, it might like tone things down a little bit, would you say?
It calms things down. Again, it gives the mediator is typically a buffer between the parties and the two attorneys. And again, it gives a neutral perspective on your individual circumstances. And again, divorces can be very emotional. So having an environment that's less litigious, more protected, is often what's needed to get people to start coming to the table and reaching what I would say typically are compromises. And that doesn't mean you're going to compromise on every element of your negotiation, but sometimes you're more willing in that environment to compromise on issues that are not that important to you, that are more peripheral. And if you see the other party agreeing to the issues that are more important to you, it becomes very conducive to starting to reach meetings of the mind, starting to reach resolution and agreement on important issues.
All right, I have a weird question for you, because this comes up on discussion with me and clients all the time, and I'm not ever sitting in on these mediations, so I have no idea. But from what I hear, sometimes the mediator says things to one party that might not necessarily be true, but maybe to get them to resolve an issue. I had talked to a husband and wife, and they both agreed the wife was going to get the home. And then, and I talked to them separate. So I didn't talk to them together. I didn't tell each other about the conversation. When they went to mediation, the wife said to me, well, the mediator said that when he brought up the idea of me keeping the house, my husband got all upset and mad and stood up and walked out of the room. And I was surprised to hear that, because I talked to the husband and he's like, I want her to have the house. So do they ever say things just to say things, just to get you to resolve issues, or is that not allowed, or it is allowed?
I would say that in my experience, that doesn't typically happen with the mediators I work with.
Okay.
For the reason that you kind of were referencing, because we don't want to create distrust between the parties. The goal is really to try to, as much as we can, facilitate a good working relationship for these people after the divorce is done. Really, on those types of issues, both parties should be hearing the same information. Now, that's different than the mediator attempting to understand each party's individual perspective, and they should be doing that. And the parties may have slightly different priorities and perspectives on many issues. But no, the mediator should not be lacking in truthfulness when they're dealing with the parties, because that does tend to backfire later. It's not an effective way of being a neutral. And I would have some concerns if I was hearing that about that particular mediator, is that should not be happening for the parties.
Okay. So it's never the mediator's job to settle the case by any means necessary. That's not what their job is.
No, their job is to settle the case, but not by any means necessary. We want all parties, when they come out of mediation, to feel like they were well informed and that they feel overall perspective is that what happened in mediation, the agreement reached, was fair to both of them.
Perfect. All right. Anything else that you think we should know about before we wrap up?
I get a lot of questions about what people need to do to prepare, and kind of tips about that and what to expect in terms of the actual day of mediation.
Great point.
Most of the time you're going to have some instructions from your attorney, but not always, or maybe you heard that from your attorney early on in the case and you've kind of forgotten that conversation, because that can happen too. But when people are going to attend mediation, we really want to make sure they're as prepared as possible to settle on that day. To that end, what you want to make sure is that when you attend mediation, that you have a clear understanding of all your assets, all your debts, that you have an idea if there's children or what your ideal parenting time plan would be, that you bring proof of income, especially if we need to address items like alimony and child support. Statements about all those debts. So if there's a mortgage on your property, we want you to bring in that mortgage statement. If we're not sure, if we're not going to sell the house, if possible, I like my clients to have an appraisal already done on the property. But the more information you bring to that mediation, the more statements that are accurate, the more likely that we're going to have an efficient and accurate accounting of all the figures that we need to work with. The last thing to that list of things that I think is very helpful for clients to do is to have some discussions with your attorney about what would be typical in your case for spousal support and child support. A lot of people go into that process without any general understanding of what the expectations should be. And it's better for you to really have that discussion prior to going into that, so that you're not talking to your cousin who had an amount of child support or alimony, and that cousin may have something completely different in terms of their financial circumstances than you will. So we don't want anybody surprised. Yeah, we want those numbers to be something that you have contemplated before, that you know what a judge is likely to do. Last thing we want to do is have someone shocked or surprised, and makes them less likely to be able to have a clear head about settlement discussions.
Right. It's nerve-wracking enough, right? And I have not met two families yet that have the exact same situation.
Right. Everybody's different in terms of that. So the best thing parties can do when they're entering this is have a good understanding what their assets are, what cash flow may look like when the case is done, because we don't want you surprised. As much as possible, we want everybody who participates to be well informed and feel comfortable with the decisions they're going to be making.
Right. I think that sounds wonderful. That's so true. I always tell people to Motrin, water, snacks.
Snacks is a great tip, because the last thing you want to do is be hungry or tired and make a decision because of one of those physical things that's going on with you.
Right. If I have someone who wants to get a hold of you and talk to you further, how can they get a hold of you?
You can email or call our office at any time. So my email is sheath@elcoreyheath.com, or you can always call our office number to schedule an appointment, which is 248-344-9700.
Wonderful. Thank you so much for doing this with me. I really, really appreciate it.
Thank you, Carrie.
I hope you enjoyed the podcast. I'm Carri Goldring, and if you ever have any questions regarding mortgage, feel free to give me a call or send me a text message, 248-420-4524. Hope you enjoy the rest of your day.